aerial kick, back kick, left punch, right punch, aerial kick. One kick.
Starting off with the introduction. It is important to note that a good essay doesn't go straight into addressing or answering the question, as we must first develop our essays properly so that the essay as a whole will bear some sense of coherence. Because the chapter in question concerns the third part of the A2 contract law syllabus, i.e. vitiating factors, we should therefore briefly define and explain vitiating factors with the focus of misrepresentation. This is where we will be briefly introducing what misrepresentation is and how it acts as a vitiating factor that can cripple or invalidate a contract. From here, we can connect our discussion to the core focus of the question, i.e., briefly introducing the characters as well as the main issues in relation to the discussion of misrepresentation. Now that we are done with the brief introduction of misrepresentation as well as the issues in the scenario, we should then endeavor to state our objective for the essay. The objective comes in the form of a thesis statement which must address the question, or at least the focus of the question. It is good to have a thesis statement as this will give the examiner a clear insight of where we are going with our essay, and also to keep us from digressing in our discussion and to ensure that we remain close to what the question is asking us to focus on. With this in mind, we will briefly explain that before we can advise if Brown has any rights against Giles, we will need to go through the common law principles of misrepresentation and apply it to the issues in the scenario. While doing so, we will have to critically consider the many aspects of the principles of misrepresentation as well as the finer points of the issues itself within the scenario to decide if there is actually any misrepresentation found in any of the issues, and how Brown can claim anything from Giles. As much as we can, the flow of our essay should be as close as possible to the flow of the events that happen in the scenario, so that the overall essay has some coherence. Point 1 of the essay should address the issue of the condition of the business and how Giles did not tell Brown that the income of the farm has recently declined because some of his customers have stopped buying his milk as they have found cheaper sources of supply elsewhere. To relate this to misrepresentation, we should now discuss requirements to establish misrepresentation, i.e., for there to be any action in misrepresentation, there must be an untrue statement, it must be a statement of fact rather than a mere opinion, and it must have induced the innocent party to enter the contract. After briefly discussing what these requirements are, we should then endeavor to apply these requirements into the issue regarding Giles's failure to mention about the farm's business decline, i.e., does his silence amount to misrepresentation? Mere silence does not usually amount to a false statement, even though it may involve in concealing some facts which is highly significant. This is especially in relation to the rule of caveat emptor, let the buyer beware, i.e., should Brown have been more careful when he was examining the accounts of Giles's business? In this situation, is Giles's silence justified? Common law has provided 5 types of situation where the law does impose the duty to disclose information, and to remain silent in these circumstances can amount to misrepresentation. A relevant situation here involves the concept of uberrime fide, or utmost good faith, in which failure to disclose relevant matters allow the innocent party to rescind the contract. This is probably the closest thing we can use that is of relevance to the issue at hand, since it concerns the sale of a business. It is possible for us to use the case of International Management Group UK Limited versus Simmons 2003, where it was decided that the basis for the rule of uberrime fide is that the relevant facts are likely to be difficult or impossible for the other party to find out for themselves. So, the law should ensure that one party does not have an unfair bargaining position over the other. As much as Giles did eventually induce Brown into getting into the contract, the issue with the silence itself is something that is probably left to the examination candidate to decide if it should amount to misrepresentation, depending on how the argument of utmost good faith is presented and applied to the situation. Point 2 of the essay should address the issue of the milking shed roof. As we have already briefly gone through the rules to establish misrepresentation in point 1, we now only need to apply the issue in this point to the rules itself. The facts of the scenario clearly tells us that following a recent storm, a builder advises Giles that the milking shed roof is in a dangerous condition and needs replacing immediately, which presumably Giles did not actually fix and yet told Brown that it is in good repair. Now, alternatively, we may also endeavor to presume that Giles did actually fix the roof, despite there being no evidence in the scenario itself which even suggests so. However, it should be noted that in examination conditions, there is only so much time for you to think too much or write too much, especially when it is a problem-based scenario question with many issues to cover. It should be understood that facts like these within examination scenarios are usually designed in a way where there is only one possible direction it can go, and this is especially so when the question specifically asks you to advise Brown against Giles. Therefore, depending on how fast you can write and the remaining time there is left, you may or may not actually be able to even mention about the alternative argument, let alone discuss it in detail. So, here we can safely say that Giles did make an untrue statement of fact, which he definitely knows to be untrue, as per the case of Dimmock v. Hallett, 1866, concerning a precise claim made about something. And in furtherance to that, this statement has inevitably induced Brown, the innocent party, to enter into the contract of sale. Point 3 of the essay should address the issue of the growing of fruits. Similarly to point 2, we need not introduce the rules of misrepresentation here as well, but to immediately apply the rule regarding the statement made into the situation. If we haven't discussed the second rule under the common law rule of misrepresentation, then here is where we must emphasize that a statement made must be a statement of fact rather than a mere opinion. The second rule is more important here for consideration because there is nothing within the short facts in the scenario about the land near the river and the growing of fruits to suggest that any one of them have any idea about growing things on any land. On top of that, earlier in the scenario, the facts clearly states that Giles is an experienced dairy farmer, and there is nothing to suggest that he is also a fruit farmer, experienced or not. The case of Bissett v. Wilkinson, 1927, should be highlighted here to show that it is possible that when Giles answered Brown that the land near the river would be suitable for growing fruit, he did so as a matter of only giving his opinion, and so the statement should not be treated as a fact, thereby failing the second requirement under the rules of misrepresentation. Therefore, it is possible to say that Brown cannot claim anything against Giles on this matter if the court should take that whatever Giles has said to be a mere opinion, a statement which attaches itself no liability on Giles's part towards Brown. In point 4, we will be discussing the possibility of a claim made by Brown against Giles, and to do that, we need to determine the type of misrepresentation that has occurred. From what we have discussed earlier, it is established that By keeping silent on the business condition of the farm, Giles has misrepresented to Brown. By telling Giles that the milking shed is in good repair when he knows it isn't is clearly a lie. And by telling Giles that the land near the river is good for growing fruits when he clearly has no clue about growing fruits is a mere opinion and therefore not a misrepresentation. By keeping silent, Giles may have possibly committed fraudulent misrepresentation for failing to mention anything about the farm's failing business condition. This is assuming that if he blatantly decided to remain silent about that matter. This is probably the same for the milking shed's condition, as he blatantly lied about the actual condition of the shed, and therefore has also committed fraudulent misrepresentation for this part. The case of Dairy vs. Pig, 1889, should now be used to explain fraudulent misrepresentation as a thought of deceit, whereby a false statement is made knowingly or without belief in its truth, or recklessly as to whether it be true or false. With this in mind, Brown is now advised to rescind the contract. And to rescind the contract, Brown must inform Giles about his intention to do so, as per the case of Carr and Universal Finance Co. Limited vs. Caldwell, 1965. However, because rescission is an equitable remedy, Brown is again advised that the court will also consider the bars to rescission. The relevant bar here is the fact that a year has passed before Brown actually wants to take any action, and according to cases like Long vs. Lloyd 1958, Brown must declare his intention to rescind the contract as soon as he is aware of the misrepresentation. Because the question asks us to advise Brown, and also because the facts in the scenario are silent on certain intricate issues, it should be safe to assume that Brown is totally unaware that he has been duped on both accounts, i.e., the business's condition and the milking shed, until he decides to take action. Therefore, with that being said, it is now possible to conclude that Brown is able to claim against Giles by asking the court to rescind the contract of sale, if it is still possible to do so after a year. As always, a simple conclusion will do. We should definitely not insert any more new points into our conclusion, otherwise it wouldn't be a conclusion. Just briefly summarize what has been discussed in the content of the essay, and highlight some of the more important points of the essay that may address the question. A conclusion for this particular question should highlight some of the key aspects of the discussion, such as why Brown can claim against Giles.